Hello, good morning, good afternoon or good evening, depending on where you're joining us from in the world. My name's Caroline and I'm the CEO of the IMRF. Thank you for joining us today. We're just going to give our colleagues a couple of minutes in case, because I can see the numbers are rising. And then we'll start. But for those of you who've already joined us, I'm really thrilled that my colleague Abby from the International President of Red Cross has joined us today. He's going to give us a presentation. My colleague Rowley Mackay, who I think most of you know, he's the our IMO rep, and also our colleague Yako, he's kindly standing in for our colleague Steve, who's not able to make it with us today. He's going to talk about the global SAR systems review. As always, if you have any questions, please put them in the chat box and we will answer them at the end when we have our Q&A. And now I think we're going to formally start. So I'm just going to run through the agenda. Yeah, as you can see, I'm Caroline. Abby's going to talk to us about armed conflicts in the maritime domain, contemporary legal challenges. Then we'll move to Rowley. He's going to talk about search and rescue in conflict situations and the work the IMRF is doing alongside our colleagues at ICRC and the Norwegian Red Cross. Then Yako will talk about the Global Maritime Systems Review, and then we'll have a Q&A. And as always, as I just said, write the questions in the chat box and we'll get to them at the end. But first, I'm just going to give a short welcome and introduction. On behalf of the International Maritime Rescue Federation, I'm delighted to welcome you to today's webinar on international law on armed conflicts at sea and the impacts on search and rescue. This marks the start of an important new initiative for us. We do not have all the answers yet, but by working together, we hope to start finding them. For those of you who may not know us well, the IMRF is an NGO that has just marked its 101 year. Our role has always been to represent, connect, and advocate for the global maritime search and rescue community. We support our members, share knowledge, and work with international bodies to improve practices worldwide. But before we start, I would like to reflect on the events that happened in Norway on Friday. There is a philosophy in search and rescue, which one of my colleagues describes as follows: after we go out, we come home, all the way home. On Friday, this did not happen, and our colleagues at the Norwegian Society for Sea Rescue lost a colleague and friend, Adrian Willison Brass, during a rescue operation where the Rescue Society's vessel had been called to assist. Adrian died while attempting to save a young girl who was sadly found dead later over the weekend. Adrian lost his own life in an effort to save others. We at the IMRF stand together with our colleagues at RS. Our thoughts go first and foremost to Adrian's wife, his little daughter, and all those who were close to him. This very sad event reminds us of the inherent risk of saving lives at sea and the unwavering dedication and commitment of the people who undertake this. At sea, risks are always present. At the IMRF, our mission is clear: to support and strengthen maritime search and rescue worldwide. We're a neutral organisation focused on one aim: ensuring people in distress at sea can be rescued safely and effectively. This isn't the first time we've engaged with the issue of armed conflict and its impacts on search and rescue. If we turn to the IMRF's founding, we engaged with this topic then, when 5 years after the First World War, at our first International Lifeboat Conference, a paper was presented by Norway on the subject that all lifeboats should have a common form of identification to signify their specific humanitarian purpose, particularly during periods of armed conflict. The paper stated it ought to be a cross to signify the humanitarian aim. The lifeboat is already known as the Red Cross of the Seas. In many ways, what we're doing now is a continuation of our work over the years in this space, upholding the principle that SAR must remain humanitarian, impartial, and protected. But gaps remain. Beyond the Geneva Conventions, there's no comprehensive treaty on naval warfare. SAR depends on frameworks such as UNCLOS, the SAR Conventions, and SOLAS, which works well in peacetime but is harder to apply in conflict. This leaves crucial questions. What protection do neutral SAR services have near and in conflict zones? And how do we safeguard personnel and infrastructure against modern threats like cyber attacks, drones, or GPS jamming? That's why over the next couple of years, we'll be working closely with our colleagues, the ICRC presented today by Abby, and the Norwegian Red Cross to explore these challenges. Together, we'll update the San Marino Manual on Armed Conflicts at Sea. We'll produce practical guidance for SAR authorities with phased publication starting in 2026. We'll carry on sharing operational lessons across the global SAR community. We'll advocate for stronger protection for SAR personnel and infrastructure. This is not a new direction for us at the IMRF, but a continuation of what the IMRF has always stood for, protecting the people and systems that save lives at sea. Today's agenda brings together experts to explore the legal, operational, and humanitarian aspects of SAR in conflict. I hope it sparks constructive and practical conversations. And finally, if you're not yet part of the IMRF or receive our newsletter, I encourage you to join us. It's the best way to stay connected with our work, support us in underpinning safety at sea, and stay connected with the global SAR community. Thank you for being here. I look forward to the discussions ahead and to keeping our shared purpose at the centre, saving lives at sea. And now I'm thrilled to pass to you to Abby, who will now hand over to her and her presentation. Thank you, Abby, for joining us. And also thank you to your colleagues at ICRC as well for all the work you're doing in working with us. Thank you.
Thank you so much, Caroline, for the kind introduction, and good morning to everyone. I just wanted to check, can you hear me well?
Yes, Abby.
Perfect, thank you. Okay, I just want to say a big thank you to the IMRF for this very kind invitation to participate in the webinar this morning. It is a real privilege to be able to talk with the search and rescue community about the law of naval warfare and some contemporary legal challenges that might be of particular interest to you. So I'm a legal advisor in the Arms and Conduct of Hostilities unit here at the ICRC's legal division in Geneva. For the last 5 years, I've focused on issues relating to the law of naval warfare and the conduct of hostilities more generally. For those who may not be so familiar, the International Committee of the Red Cross, or the ICRC, is a neutral, independent, and impartial organisation that is dedicated to protecting and assisting victims of armed conflict and other situations of violence around the world. We were founded in 1863, and we work to uphold important rules of international humanitarian law. We provide medical aid, assistance, we support detainees, and we promote respect for human dignity in some of the most challenging environments. Today, we operate in more than 90 countries, and as I said before, our mission really is grounded in impartiality and neutrality, which really does allow us to operate across borders and conflict lines to help those most in need. So over the next 40 minutes or so this morning, I will be addressing a few key topics. So first, I will offer an overview of the complex legal framework that governs armed conflicts at sea. Next, I will focus on some specific legal safeguards that are designed to protect lives and vessels. Then I will conclude the presentation by speaking to some recent efforts and developments aimed at clarifying and evolving the law of naval warfare. I should add a short caveat that at the Red Cross, in accordance with our principles of neutrality and impartiality and our practice of confidentiality, I'm not going to be focusing on any specific situation or context, because I will rather just discuss the rules that apply particularly to armed conflict between states more generally. So since the 19th century, maritime warfare has been transformed. In the age of sail and steam, battles were fought largely on the surface, and submerging meant almost certain death. Then came sea mines and submarines opening a battle space below the waves. With aviation in World War I, naval conflict expanded upward, creating the first truly three-dimensional fight on, above, and below the sea. Now, today, the maritime domain is far more complex. Navigation, communication, surveillance, and targeting all rely on technologies that extend into space, cyberspace, and the electromagnetic spectrum. Modern naval warfare is multi-domain by design. Today, navies project power across vast distances. Long-range weapons, stealth, hypersonics, they're all changing the speed and geography of conflict. Navies operate in contested littorals where sea, air, land, cyber, and space converge. The threats are diverse: unmanned systems, precision missiles, swarming fast attack craft, and still there is the enduring danger of sea mines. Now, beneath the wave lies another vulnerability, and that is critical undersea infrastructure. Submarine cables and pipelines carry the lifebloods of our societies. Now, in the world wars, cable cuts were serious, but they didn't collapse global communications and financial systems. Today, disruption would strike at civilian life itself, affecting everything from salaries to food and medicine. Submarines, of course, remain dominant, and they're also now enhanced by unmanned underwater vehicles. Drones extend surveillance and strike where traditional aircraft cannot. And across space and the cyber domains, as well as the electromagnetic spectrum, controlling or denying access by armed forces is considered mission essential for them. Now, of course, navies are not alone. We know that armies and air force project power at sea with artillery, aircraft, and missiles. And maritime operations are joint, often multinational, and they take place in a domain that's shared with corporations, humanitarian actors, NGOs, private security, militias, and non-state actors, each pursuing their own agendas. Now, most naval warfare happens in international waters, that is, water beyond the sovereignty of any single state. But these waters are far from empty. They are busy, crowded, and alive with activity. Countless actors operate there every day, and most are neutral, completely unconnected to the fight. The ocean is a global commons today, and it matters more than ever. We know that tens of millions make their living fishing or farming at sea, and they feed millions more. When it comes to energy production, oil, gas, offshore wind, and new green technologies all depend on the ocean. Almost all of our global communications run through cables on the seabed. We have rare metals beneath the waves that power technologies we use every day. Some, of course, travel by using the sea out of need, others for leisure. For example, over 20 million Americans cruised in 2024 alone. And the ocean produces half of the world's oxygen. A living ocean, of course, means a living planet. And over 80% of goods traded globally are transported by sea, and of course, we'll come back to that. Now, when conflict erupts at sea, it affects far more than the belligerents, and that much is clear. It touches trade, food, energy, communications, migration, leisure, and even the air we breathe. Now, for armed forces operating in conflict at sea, maintaining command, control, and communication is a major challenge. Operating at distance reduces situational awareness, and that often forces commanders to make critical decisions with limited information. To survive, forces are employing tactics of deception and signature management. When you combine that with dense maritime traffic, narrow choke points, and overlapping claims, we know that this greatly increases the risk of misidentifying civilian vessels and harming seafarers. These challenges also complicate rescue and evacuation of the wounded, shipwrecked, deceased, and detainees. Now, of course, the adverse impacts of warfare at sea for the civilian population do not simply end where the waves lap the shore. What happens at sea today deeply affects civilians on land, and keeping sea lines of communication open is vital to ensuring that food and essential goods can access civilian populations. Blockades, exclusion zones, or sea denial operations can trigger humanitarian fallout. And of course, we see attacks on coastal cities and ports killing thousands, displacing millions, and devastating ecosystems in large-scale conflicts. Civilians also fleeing conflict zones will face perilous journeys, and many choose to evacuate using their own vessels or overloaded civilian ships, which of course increases the risk of accidents and the loss of life. We see these evacuations often starting from ports or beaches that are also military zones, which could compound the danger. Now, at the same time, we understand the oceans better than ever. We understand their fragility and the role in sustaining human life. And we know that the environmental destruction that has been tolerated in past naval conflicts should not be tolerated or acceptable to states today. Now, when it comes to maritime shipping, few sectors are as exposed to global conflict as maritime shipping. Historically, civilian crews faced enormous risks. In World War II, for example, a merchant seafarer was more likely to die than a soldier on the front lines. If we take, for example, the United States, who lost 350 warships, but over 1,500 merchant vessels. Japan, for example, lost 686 warships, but more than 3,000 merchant vessels. Now, today, merchant shipping looks very different. Global trade is faster, more interconnected, and indeed more vulnerable, which is challenges that the law of naval warfare never anticipated. Nearly 80% of world trade moves by sea, carried by over 100,000 vessels over 100 gross tons, registered in more than 150 nations, with nearly 2 million seafarers and millions more in fishing fleets. Ownership, crews, and cargo are increasingly multinational, and they're often disconnected from a single flag state. Now, if we take, for example, the world's largest container ship is Swiss-owned, Liberian-flagged, operated by a multinational crew, and capable of carrying over 24,000 containers bound for markets across the globe. Today, nearly 3/4 of the global fleet sails under flags different from their real owners, making flag alone an unreliable way to distinguish enemy from neutral vessels. And we see civilian seafarers, often with no ties to any conflict, still caught in the crossfire. Now, with global trade dependent on the sea and even brief disruptions being able to ripple worldwide, modern naval warfare makes safe passage harder than ever. We see merchant ships being targeted at long range, navigation being disrupted, and civilian mariners facing constant danger. And at the heart of this are ordinary seafarers, the people who keep the world moving yet remain largely invisible. Every missile, drone, naval mine, or risky cargo voyage puts their lives on the line. We have front lines cutting through shipping routes and ports, forcing crews to endure longer, riskier voyages, and that's all to sustain the supply chains that civilians depend on every day. So now that we've seen what modern conflict looks like, we should now turn to what the rules that govern it. These rules are designed to strike a delicate balance. They protect the rights of those that are engaged in conflict, but they also safeguard those who are not or no longer participating. That's the wounded, the sick, the shipwrecked, protected persons and vessels, and neutral actors that are navigating the global commons. Now, when you look at from the 16th century through to the Second World War, it is great power naval wars that really did shape the legal foundations of warfare at sea. Driven by imperial rivalries, these conflicts involved campaigns of commerce raiding and blockades that have been designed to choke trade, deny contraband, and weaken the enemy's ability to fight. This history has profoundly influenced how we understand naval warfare and the laws that govern it. Now, of course, since the Second World War, large fleet battles have mostly disappeared. Modern naval conflicts today are smaller and regional, and they're not necessarily global. There are a few wars in the years since the Second World War that have focused on maritime control, but navies have certainly played critical roles. They have enforced embargoes, they have struck targets on land, they've moved troops, they've gathered intelligence, and as we've seen in the Iran-Iraq tanker war and the Gulf Wars, naval conflict was significant. Though economic warfare at sea is less common, we do see that naval operations do pose serious humanitarian, legal, and environmental risks. Civilian shipping, coastal infrastructure, and marine ecosystems remain vulnerable. Now, when it comes to the law of naval warfare, I need to make clear at the outset that it's not simply a case of the law of land warfare or international humanitarian law with water added or poured on top. It's something distinct that is shaped by the sea itself, bearing in mind that the fighting unfolds in international waters, which are indeed a global common crowded by neutral actors. It seeks, the law itself seeks to allow economic life to continue, even when there is conflict happening around it. Today, the law of naval warfare itself is composed of 3 pillars. So firstly, that is the international humanitarian law applicable at sea. That is the rules governing the conduct of hostilities and the protection of people. Second, prize law, which is the legal framework for capturing vessels and cargo. And thirdly, maritime neutrality law, which regulates how neutral states and their shipping are treated during conflict. Now, each pillar has its own legal function, but none of them stands alone. They are interwoven, overlapping, and interconnected, and a single action at sea may implicate all 3 at once. Now, of course, the framework that applies during armed conflict does not just stop there. It extends beyond the law of naval warfare per se. It touches upon the law of the sea, as codified in UNCLOS, human rights law, and even international environmental law. All of these bodies of law operate together, shaping what states can and cannot do when conflict breaks out at sea. Now, I talked about the first law being international humanitarian law applicable at sea. That is the body of treaty and customary rules that protect people and objects. It safeguards combatants and those not taking part, such as the wounded, shipwrecked, prisoners of war, civilians, and the natural environment. It also limits how wars can be fought, restricting certain weapons and tactics. We can find the main sources of these rules in the Geneva Conventions, the 4 of them, which have been ratified by every state in the globe, across the globe. There are additional protocols and the Hague Conventions and customary law. Now, in naval warfare, it's important to note that IHL applies equally to all belligerents, regardless of who started the war. It's about conduct and not cause. Now, as you all may know, the Second Geneva Convention is central to naval warfare. It enshrines a core principle that the wounded, sick, and shipwrecked, and thus those that are rendered hors de combat, must be cared for equally, whether they are friend or foe. It mandates rescue at sea, protects medical vessels, and emphasizes respect for those who die in hostilities. The convention reflects the very profound fact that the unforgiving nature of the ocean can really be as perilous as the adversary itself. Of course, other aspects of the Geneva Conventions are relevant, particularly when it comes to those that are captured at sea and detained in the Third Geneva Convention. And then there are important provisions in the Fourth Geneva Convention regarded to shipwrecked civilians. Now, if we look at the additional protocols that were adopted in 1977, they strengthen many of these protections. They expand safeguards for civilians and medical vessels. They update the rules on humanitarian access, which is critical for the conduct of naval blockades. And importantly, the additional protocol codifies crucial principles guiding the conduct of hostilities. Here we can think of distinction, proportionality, and precautions. These principles ensure that parties clearly separate civilians from combatants. They avoid excessive harm relative to military advantage, and to take all feasible steps to protect civilian lives and property. So that's the first pillar. Now, we turn to the second pillar. As I mentioned before, economic warfare was once central to naval conflict, and at its core was the law of prize. This law gave belligerent forces the right to capture enemy merchant vessels and sometimes even civil aircraft. Neutral vessels, meanwhile, could be seized, but only for cause. Now, once captured, these merchant vessels and aircraft could be condemned in prize courts, and in rare cases, destruction at sea was permitted. Now, the practical mechanism for exercising prize law was that warships would exercise the right of visit and search, boarding the vessels to assert control. But here's the question that arises today, is whether this law still makes sense. Many, in fact, argue that it doesn't because they see it as an anachronism. They view the law of prize being born of maritime imperial rivalry, and it is seen as increasingly outdated. Academic experts really do question the law's relevance, practicality, and even legality. Now, even if economic warfare at sea returned on the scale of the past major naval campaigns, we know that future naval warfare will look very different. For example, searching a modern container ship for contraband would be practically impossible today in light of the evolutions in modern shipping. Of course, long-range weapons, stealth technology, and unmanned systems change the game almost entirely. And we have these measures in prize law that were crafted for another age that need to be carefully adapted to the realities of conflict at sea. Now, although there are some that question whether this law still makes sense today, and it is quite an old law, there are many states that still consider prize law to be good law today, and it still appears in many of their legal and military doctrines, which is an important point to note. The third pillar is, of course, the law of maritime neutrality. It governs how neutral states, that is, those states that are not participating in the conflict, and belligerent states interact during armed conflict. It sets out both the rights and obligations of neutral states, and it also explains how belligerents need to be treating neutral states in hostilities. The law of maritime neutrality has a number of rules that relate to how belligerents may what they are required to do to respect the inviolability of neutral waters, and also what neutral states are required to do to prevent belligerents from using their neutral waters as a base of operation. The challenge is that there are many of these rules are based in custom, and some of those, and there is some lack of clarity as to how those rules apply today. Now, I said that the law of naval warfare rests on three pillars, that is IHL, prize law, and neutrality, but it doesn't stand alone. It sits within a broader web of international law that has developed in the last half century. And much of that law applies in peacetime, which you would be familiar with, I'm sure. So we have law of the seas codified in UNCLOS. We have IMO conventions such as SOLAS, SAR convention, and the coal regs. We have, and then alongside we can think of human rights law, environmental law, air law, even criminal law, the UN Charter, and decisions of the UN Security Council. Now, the challenge is to work out how all of these rules apply and interact. It is a complex challenge, and it's often debated between states and academic experts and others. But together, importantly, these frameworks do apply and shape the legal framework in which modern naval forces operate. Now, as Caroline mentioned, there's no single treaty that covers all of the rules of naval warfare, unfortunately. We know that there are multiple treaties, a lot of customary law, much of it old, and historical practice. Many key rules have never been formally codified, which makes it really complex to know which laws apply. So to clarify these gaps, there have been several soft law instruments that have emerged, and most notably is the San Remo Manual on International Law Applicable to Armed Conflicts at Sea that was finalized in 1994. For the last 30 years, this manual really has become the widely accepted restatement of customary international law. It has been cited in military manuals and international forums, and it is considered a really important document for practitioners. The manual itself was created by a group of legal experts and naval practitioners acting in their personal capacity, and the project was led by the Institute of International Humanitarian Law in San Remo with the support of the ICRC. And it was a 7-year effort. Now, as you've already heard, there are significant changes into the way that naval operations are conducted, and there are key legal developments. And so it's time for an update, and that is the project that is ongoing, which the ICRC is actively involved in alongside the Institute for International Humanitarian Law and the Norwegian Red Cross. And the IMRF, as Caroline said, is supporting this work as an observer. Now, having outlined the key legal regimes that apply during armed conflict at sea, I'd like to turn attention to some vital legal safeguards that are designed to protect lives and vessels at sea. Now, as you know very well, in today's maritime world, every vessel sails under the flag of its flag state, which is where it's registered and signifies its nationality. Since the ship's flag determines its legal status and the laws it must follow, verifying the authenticity of the flag is crucial, including during armed conflict. Now, under the law of naval warfare, vessels are legally classified as either neutral or enemy. A neutral vessel belongs to a state not involved in the conflict, while an enemy vessel is part of the conflict, as viewed by the warring sides. Now, this distinction between enemy and neutral is not just theoretical. It has practical consequences during naval warfare, especially regarding how parties may employ certain means and methods of warfare, detention operations, and humanitarian obligations, just to name a few. Now, for naval vessels that are owned or exclusively controlled by the armed forces, identifying their status is usually very straightforward. However, determining the nationality of merchant vessels can be much more complex, and I'll dive into that in a few minutes. So if we look first to warships, a warship is a state-owned military vessel. It's clearly marked to show its character and nationality. It's commanded by a commissioned officer, and it's crewed by personnel under military discipline. Enemy warships are lawful military targets, and only warships are permitted to exercise belligerent rights, such as visit and search, diverting and capturing vessels, mining waters, and conducting attacks. Now, advances in technology have of course, seen the advent of uncrewed or unmanned maritime systems, which raises questions about their status under the law of naval warfare, of course, also under the law of the sea more generally. We know that states take different views on whether these vessels can become warships or whether they are merely vessels or simply means of warfare. And this is a key distinction, since warship status determines the rights that they are allowed to exercise in armed conflict. So next, if we turn to auxiliary vessels, these are ships that are owned or exclusively controlled by a state's armed forces, but they are not classified as warships. These vessels can serve government non-commercial purposes, and they can be crewed even entirely by civilians. In naval conflict, auxiliaries play vital support roles, freeing up expensive and scarce warships for combat. We see that they conduct tasks such as refueling, logistics, troop transport, and amphibious landings, and mine countermeasures. We know that many countries operate such vessels and are likely to do so if they were to end up in armed conflict. Now, unlike warships, auxiliaries are not legally permitted to exercise belligerent rights, but they can still be targeted during armed conflict, unless in exceptional cases they have been granted special protections, such as they've been converted to a hospital ship, or they have been performing the role of a cartel vessel, for example, transporting prisoners of war. Now, if we turn to merchant vessels, which creates some particular challenges, these are all ships that are not warships, auxiliary vessels, or state vessels like customs or police boats. This includes everything from container ships, passenger liners, to private yachts, fishing boats, and pleasure crafts. The nationality or character of these vessels have really important implications under law of armed conflict. We know that they sail under a single state's flag, which defines their nationality under UNCLOS. And in conflict, a ship under an enemy flag is clearly of enemy character, but a ship under neutral flag is only just presumed to be neutral, and that presumption can be challenged. If a warship commander suspects a neutral flagged ship is acting with enemy character, then they may decide to board, search, and if justified, divert the ship. Now, if their suspicion that this neutral flagged vessel is acting with enemy character proves reasonable, then the vessel can be captured and brought before a prize court. Enemy character is not determined just by the flag, but also by other criteria, such as registration, ownership, operation, or charter. Now, today, as you all know very well, this makes it even more complex because open registry, flags of convenience, multinational crews, and cargo are often unrelated to the flag state, which makes verifying a vessel's status and its character in conflict much more challenging than in the past. During armed conflict at sea, belligerent warships and military aircraft have the legal right to visit and search merchant vessels outside neutral waters, and that is important to know. They can do this if they have reasonable grounds to suspect the vessel is subject to capture. Now, they can also divert such vessels to an appropriate area or port for the purpose of exercising visit and search. When it comes to enemy vessels, whether merchant ships or not, they can be captured outside neutral waters. We know that neutral merchant vessels do benefit from much stricter rules, and they can only be captured in certain circumstances. For example, if they are engaged in activities that may render it liable to attack. But they can also be captured if they are carrying contraband, that is, goods that are ultimately destined for territory under the control of the enemy, and that they are susceptible for use in armed conflict, provided they are published on contraband lists. They can also be captured if they are breaching or attempting to breach blockade or operating under enemy control or orders. Neutral cargo itself can also be seized if it is on, as I said, an official contraband list. In certain rare exceptional cases, captured merchant vessels could be destroyed at sea as a matter of last resort, but this is permitted only when adjudication as prize beforehand is impossible, and there must be strict conditions that are met, relating to the safety of the passengers, the crew, as well as preserving key documents and also ensuring, where possible, saving of personal belongings. Now, crucially, a ship cannot be destroyed simply for carrying contraband unless that contraband makes up more than half of its cargo. And even then, any destruction at sea must still be subject to later proceedings in a prize court. So that's visit and search, diversion and capture of merchant vessels, which is quite a different regime at sea, and no parallel exists on land. When it comes to capture, it needs to be effected by a prize crew on board the vessel, as well as an important point. And then there are certain vessels that are exempt from capture, which I'll discuss shortly, for example, hospital ships and coastal rescue craft. Now, when it comes to targeting of merchant vessels, they are prima facie civilian objects, which unless they, by their use or conduct acts that turn it into becoming a military objective. And such acts might include carrying out various belligerent acts on behalf of the enemy, acting as an auxiliary to the enemy, being incorporated into the enemy's intelligence system, or sailing under enemy convoy. So in effect, a merchant vessel can be targeted when it makes an effective contribution to the enemy's military action, and that its destruction would be advantageous for the belligerent in the circumstances at the time. Also, there are certain cases where merchant vessels that clearly and intentionally refuse to stop after a warning to stop by a belligerent, or being considered to actively resist visit and search, also render themselves vulnerable to attack, and in certain circumstances may be attacked. Now, all of these attacks must be subject to the principle of proportionality and precautions, as I mentioned earlier, which provide important protections. The challenge is that how these rules apply in practice are not always clear. Now, there are certain vessels that are protected from capture and attack, and I'll focus in particular on the first two, which is hospital ships and small craft used for coastal rescue. But as you can see on the slide, there are a number of medical transports, including medical aircraft that are granted protections, both of the warring parties as well as neutral vessels that have taken on board the wounded, sick and shipwrecked or dead. There are also protections for aircraft and vessels that are granted safe conduct by agreement between the parties, such as for exchange of prisoners of war or engaging in relief and rescue operations, and passenger vessels who might be carrying civilian passengers, including when civilians might be evacuating. Now, to be protected, these vessels must carry out their normal duties. They must avoid harming the enemy, and they need to cooperate with identification and inspection requirements, and they must follow orders without intentionally hampering the movement of combatants. And only then can these vessels claim exemption from capture. Now, protection against attack is stricter because a vessel may only be attacked if capture or diversion is impossible and the breach itself is serious enough to qualify it as a military objective. And the attack, of course, must not cause excessive harm relative to the military gain. Now, hospital ships in particular enjoy an even higher level of protection, and protection is only lost for them after a proper warning with a reasonable deadline is given and ignored. And in such cases, it then may be subject to capture or other enforcement measures, but attacking a hospital ship really is a last resort. Now, identification of such vessels can be done by inputting crosses on a white background, visible on both sides and the top of the vessel. But we know that, as has been evident even back to the Second World War, that markings on the vessels themselves are not sufficient to identify them. And if we consider, for example, that in the Second World War, more than 45 hospital ships and 4 ships chartered by the ICRC were sunk at sea. Now, when it comes to small craft that are conducting coastal rescue operations, they need to be respected and protected as well. And they must be allowed to carry out their duties, but as long as operational needs, so far as operational requirements of the belligerents permit. So it's important to note this is not an absolute protection. Now, even though it refers to coastal, this does not just mean near the shore. It includes any craft that is based on the coast, even if they're operating far out at sea. Unlike hospital ships, there's no formal warning requirement if rescue craft violate their exemptions for protection, which is why clear identification and communication is essential. We know that, as I said before, visual signals alone are insufficient. So things like acoustic, electromagnetic, and electronic systems like AIS may help prevent accidental targeting. Now, at sea, both military personnel and civilians face serious risks, and they can be wounded, fall ill, or become shipwrecked due to the hostilities. The law itself defines the wounded and sick as anyone, whether it be military or civilian, who needs medical care and refrains from hostile acts. Shipwrecked persons are those people that are in peril at sea or other waters because of misfortune affecting them or their vessel or aircraft. And crucially, they must also refrain from the hostilities. This can include people stranding on a burning ship, a disabled vessel, or even those that have run aground. The cause of the distress itself may be human error or mechanical failure. It need not necessarily be enemy action. But importantly, those individuals remain shipwrecked and therefore protected during their rescue, whether they're on life rafts, boats, or picked up by coastal rescue craft until they receive a new status. Now, when it comes to search and rescue at sea, obligations, the parties to the armed conflict have clear obligations to take all possible measures to search for and collect the wounded and sick, the shipwrecked after each engagement, and to ensure their adequate care. And that is the same with the dead as well. Now, this is an obligation of conduct requiring good faith and due diligence that's adapted to the specific situation. Not every warship or forward-deployed unit must immediately rescue casualties, but they must consider alternatives, be it alerting land authorities, neutral ships, or humanitarian organizations capable of rescue. The rule itself is flexible, yet unwavering, and all feasible measures must be taken to protect those in peril. And in this sense, neutral vessels play a crucial role. And parties to the conflict can, and they should, and in some cases are legally required to appeal to neutral vessels to assist. And blocking or discouraging neutral vessels from assisting would violate international law if it's done arbitrarily. Of course, neutral vessels may act on their own initiative, and when they do, they receive special protection and they're not subject to capture. We know that this isn't just a matter of charity. This response may also be legally required under broader international maritime law obligations, such as the SOLAS and SAR conventions. We know that safety limits might limit this duty in armed conflict, but masters of neutral vessels may feel compelled to provide rescue even without formal appeal. As I said before, parties must also search for the dead and prevent them from being despoiled. And this also includes allowing other capable entities to help if it's not possible. Of course, priority will go first to the wounded, sick, and shipwrecked. The dead must also be identified, and burials at sea must follow careful processes. We also see advances in technology such as unmanned maritime systems who might also be able to support recovery, but of course expectations remain reasonable given the circumstances. Now, I wanted to mention an example or an interesting example or good practice that took place in the South Atlantic conflict. The Red Cross box was a 20-kilometre neutral zone that was created during the 1982 conflict between Argentina and the United Kingdom. It was located on the high seas about 20 nautical miles north of the Falklands Malvinas. It was created by agreement between Argentina and the UK. The zone itself was reserved for hospital ships and medical transport. There was one British and two Argentine warships, or hospital ships, that operated there. And they were supported by 3 additional British vessels that were used to transfer casualties from both sides. In that conflict, over the period of a few months, more than 700 wounded personnel were treated, and the ICRC monitored the zone itself to ensure compliance with international law. Now, this is a practical arrangement. This arrangement that was agreed between the parties was to address practical challenges when you have one party operating far from medical facilities, while the other faced risks related to evacuation at sea. Although it's not explicitly required but by the Geneva Conventions, it really was one way of implementing the key principles of IHL at sea by drawing on concepts that are familiar on land warfare, such as hospital zones and neutralized zones. Certain practices like this might be useful examples for future conflicts, but the most important thing when it comes to agreements to practices like this is that it requires agreement between the parties themselves. So I've talked about moving from some specific protections. I now want to sort of talk a bit more about some of the challenges with applying the law of armed conflict or the law of naval warfare at sea today. Now, as I've already said, much of the law is based on customary law, particularly from older treaties, and many of which do not have widespread ratification, leaving many gaps and uncertainty. A major challenge, of course, as I meant, is the overlapping legal regimes and how the law of naval warfare, that is IHL prize and neutrality law, intersect with the law of the sea, human rights, and other important frameworks, including environmental law. So it becomes very complex to determine which rules apply, and states and other experts do not always agree. The other challenge is that traditional laws were developed for fleet battles, and they face pressure from the modern nature of naval warfare. There are questions about how to apply these old rules but in light of legal developments that have occurred in other domains, such as on land, in cyber, space, and air, for example. So the new technologies are forcing us to rethink existing rules. There are, of course, questions around the suitability and acceptability of economic warfare at sea, be it blockades, the exercise of contraband and prize measures, and that is a particularly contentious issue in light of today's evolved maritime shipping sector. Now, of course, much of the law assumes that it's conflict between states, but we know that there is significant complexities for non-international armed conflicts where the legal practice and interpretation of rules varies widely. So this brings me to, and just to say, you know, there are many academics who have written about trying to answer the question of whether the law of naval warfare needs to be brought into the 21st century. As an example, you know, there are academics who say that it needs to be updated, while meanwhile there are other academics that say that the traditional law needs to be preserved. This brings me to the update project that is ongoing on the San Remo manual. There has been a widespread acknowledgement that the manual needs to be updated to reflect evolving state practice and modern naval operations. The project itself began in 2019 led by the International Institute of International Humanitarian Law in San Remo. The progress in the early years was made. There was progress made, but there were some delays due to the pandemic and financial constraints. Now, since last year, there has been renewed momentum for this project from the steering committee and with the active support of the ICRC and the Norwegian Red Cross Society, and we have received generous funding from the Norwegian Ministry of Foreign Affairs. We have an expert group that is composed of a diverse group of legal and practical expertise from all regions, state, naval and legal practitioners acting in their personal capacities. We have academics with a range of legal expertise and observers such as the IMRF and the International Shipping Council. So the current aim is to finalize the manual, including the commentary within the course of 2027, and then we envisage the consultation of states both during the process and at the end. Now, finally, before I hand over, I just wanted to mention another initiative related to seeking to clarify the rules on the law of naval warfare, and that relates to a global initiative to galvanize political commitment on IHL that was launched last September by the ICRC together with Brazil, China, France, Jordan, Kazakhstan, and South Africa. The global initiative aims to make IHL a top political priority worldwide, and to ensure that IHL is always part of the conversation when armed conflicts are discussed. But alongside this initiative, the political focus that is, we have a technical focus, which is aimed at developing practical recommendations for states and belligerent and parties to armed conflict to strengthen respect for the law of naval warfare as one of its important work streams, which is being chaired by Egypt and Indonesia. So we've had a number of important discussions with states and experts related to these issues to sort of gather their views and create a space for them to discuss with the objective of coming up with some high-level political recommendations related to protection at sea. And so with that, and we're looking at having some upcoming consultations which are very related to the conduct of hostilities and the protection of the wounded, sick and shipwrecked. So with that, I will have gone a bit over my time here. I'm very sorry for that. I will hand over to Rolly for his presentation. Thank you so much for the opportunity to deliver this presentation.
Thank you, Abby. That's fascinating, and it's very complicated. Can you hear me okay? I'm just double checking that the microphone is working. Somebody just say yes. Great, thank you very much. Apologize, I am getting over a cold, so I'm a little bit sniffly here. Okay, so as Abby said, I took part in the recent San Remo meeting, which took place a few weeks ago, and I listened in to the conversations and the discussions, and as Abby has laid out there, it's a very complex legal environment, and the maritime environment itself causes a great number of difficulties in working out how the rules apply, because there are so many overlapping rules around territorial waters, contiguous zones, international waters, neutral spaces, internal waters, the whole 9 yards, and war at sea can take place globally, as we know from history, sadly. So I'm going to take a practical approach to this. What does it mean, or what could it mean for search and rescue operations? How will it impact on search and rescue operations? And Abby's made a few points about the the protection of coastal rescue craft, the word that's used. And coastal rescue craft definition means more than. We know the world has changed and people operate rescue capabilities from motherships and other ways of doing these things. So this is some thoughts on the discussions as I've heard them so far. Abby can chip in at some point, and if I misunderstand something, she can certainly put us straight. We do need a lawyer alongside almost for most of these conversations. So the San Remo manual on international law applicable to armed conflicts, it's a comprehensive codification of customary and international law, etc., etc. Interestingly, there was some work done in the International Aviation and Maritime SAR manual. So in volume 1, which is for SAR administrators, for the people designing, building and operating a system, section 1.8 talks about the international law applicable in a general sense. So search and rescue operations by maritime rescue services in times of armed conflict. The guidance contained was prepared by the International Committee of the Red Cross. So we have some guidance, but that is for SAR administrators as a general statement. And there's 1 or 2 pages, I think, of information in there around protections of rescue craft, shore-based services, MRCCs. But a lot of it in the IAMSAR manual I noted was it is good practice to mark your boats and good practice to mark your RCCs, and it's good practice not to attack them. As we know, wars, unfortunately, are complex, confusing, frightening, and people make mistakes and people do things they shouldn't do. The manual consists of general provisions, regions of operation. So as we've talked about, internal waters, territorial seas, archipelagic and international straits, EEZs, continental shelf, the high seas. This does spread globally. The rules around this are global. It's not like a land conflict, which may be contained by the fact that it's a land environment. This is potentially global. There are some basic rules around target discrimination. So it talks about lawful targets, emphasis on the protection of civilians and neutral parties, and requires warnings and proportionality. Abby's already mentioned some of that in more detail. Also talks about methods and means of warfare at sea. And as we know, technology has changed considerably from when the initial rules were made back in the sort of pre-First World War. I think it was 1907 when the Hague Convention was first made, and the lessons of the First World War, the lessons of the Second World War, and all those other things which affect us. But there is a completely different technological environment in which SAR is operating in nowadays. So a few things that we might need to discuss around the San Remo manual and the laws of armed conflict at sea. Obviously, technology is a significant game changer in the modern age. 75 years ago, lifeboats were lucky to have radios. Now, we make extensive use of the radio spectrum for search and rescue. We use radio communications, the AIS system, navigation signals. We're receiving the GNSS signals to enable us to operate the boats and navigate precisely where we need to be. Exchange of data is becoming a thing, exchanging SAR data using data communications, and the distress alerting devices and systems in the GMDSS, the EPIRBs, DSC, radio itself, all make use of the radio spectrum. But of course, in modern warfare, that the belligerents wish to disrupt and prevent the use of that spectrum to prevent the enemy or to make life harder for the enemy. But that jamming and spoofing and the intentional destruction of those systems, which may be likely, right, satellite shore stations might be destroyed if it's in a belligerent state, is all going to affect search and rescue enormously if it removes the capabilities. You only need to think about how you're going to dispatch and coordinate a search and rescue operation if the radio spectrum is jammed and you can't communicate. You're going to step back into literally the pre-radio 19th century. You're going to scribble on pieces of paper, maybe using telephones if they're still working, and the last piece of information you may have about a situation is very old and very confusing. So I'm uncertain how we deal with that and how you can prevent, for example, AIS being jammed if the radio frequencies that AIS uses is being used by belligerent states for other purposes, and so therefore is jammed, or is jammed by accident because there's frequency spread across the frequencies, broadband jamming, etc., etc. Identification of SAR craft by combatants, if I can get my words out, both electronic and visual. Clearly visual, we can paint them with the relevant symbols. The boats need to be white with either a red cross or a red crescent or the red crystal painted on them very clearly to make them obvious. The same goes for RCCs. But of course, electronic identification of rescue craft is going to be vital in a combat environment in the modern age where many weapons can be used over the horizon. A target can be identified electronically and a weapon can be fired at that target without it being visually identified. And of course, fast, small rescue boats look like fast attack craft. So in terms of radar and some other identification, there is electro-optical cameras and things might be able to help. But in the panic and fear and confusion of warfare and warfighting, operators on warships may be less discriminatory than they should be. So we have to think about how that happens. Talked about coastal rescue craft. Abby said that it includes more than just coastal rescue craft. Excuse me. Recognizing that coastal rescue craft operate quite a considerable distance from shore, but of course there may be rescue craft out there operating from motherships. There may be fast rescue boats operating from neutral ships who are responding to persons in distress. There are all kinds of confusions here. The management and coordination of search and rescue in a conflict area is going to be extremely challenging, I think, certainly at first glance. And also search and rescue on the periphery of a conflict area may be affected. Even though you are not involved directly, the conflict, which may be very close next door or in a sea space that you are working in, may ripple out and affect your operations. And we already see that in parts of the world where there are problems with GNSS signals and other radio communication. We talked about, or Abby talked about, the passing neutral or non-engaged ships. What are their roles and protections in SAR? Well, there kind of are protections, but a merchant ship, which is not painted up as a rescue ship, it's just passing and is asked to assist or comes across people in danger, but stops and gets involved. How do they inform the belligerent parties that they are doing this? How do we make it certain that that ship is protected? It's an object on radar, for example. In a jamming environment, how do we confirm that these ships are identified as neutrals and non-combatants, etc., etc.? Major challenges, I think, from the practical operator perspective. Protection of shore-based SAR infrastructure. The ICRC information in the IAMSAR manual mentions rescue craft and shore facilities, so maybe rescue boat stations and RCCs. But of course, what about the communications infrastructure that is used by them, the radio aerials that they make use of, the radio systems, the telecommunications network, which is critical to search and rescue coordination, rescue team call-out systems, which are often based on paging or mobile phone alerting type call-out processes, fuel supplies, food and water. If a conflict is going on for a long time, can the rescue boat, rescue craft organization maintain protection of its fuel supplies, and how does it get fuel as it starts to run out, and food, water supplies, protection of SAR personnel. They may be civilians in a belligerent state. There are two states. They are personnel. Are they protected in some way? What is their status? Can they continue to operate as rescue craft personnel? We have to think about aircraft as well. I made a couple of notes. One is what is the status of military registered SAR vessels and aircraft? And police boats, which often conduct search and rescue, which are state vessels. Do they change their status when they're doing search and rescue? Is it a permanent status? All of those legal discussions and practical discussions in a, excuse me, a conflict situation. SAR response to civilian vessels and aircraft in a war zone by military vessels and aircraft. There was an interesting scenario discussed during the San Remo document discussions about a warship which rescues civilian personnel from a sinking civilian ship and takes them on board and transports them, or tries to transport them, to a shore location to offload them and then continue back on its war duties. What is the status of that military vessel? Is it just tough? The civilians have to take the risk of being on a vessel which can be attacked, and in the scenario the vessel was attacked. What happens? How do you alert the belligerent parties and everyone else involved to a status change of a vessel? We have, 500 children on board this military vessel, and then taking them to shore, etc., etc. And I use deliberately an emotional scenario idea there, because that's the kind of thing we might have to deal with. How do you alert people? How do we make sure the status is clear and obvious in an electronically jammed environment, where the electronic status can't easily be obvious? Status of rescued survivors. Well, there is rules already around military personnel and their status versus civilians, neutrals and conflict parties. I do have a question which is probably can be answered by the lawyers, but it's what if a lifeboat service rescues military personnel from a sunken military vessel or a crashed military aircraft? What is their status on board? Because they may be from the other side, so to speak, from an enemy nation, or they may be their own nation. But what happens if a warship from the other side comes across the rescue boat? I presume they can be searched, and I don't know what Abby can perhaps fill in on this. Can they be taken away from that SAR vessel if they are the enemy and captured as prisoners of war at sea, and all of those things? Complex scenarios. There's a whole idea here that we have some tabletop scenarios to discuss some of these ideas and work through the scenarios to test all of the legal elements against what is going on in a practical SAR environment. And as Abby said, the SAR Convention and all the other UN Convention on the Law of the Sea and other UN and IMO conventions still apply. On top of all of this, in the middle of a war, the other things still apply. You're not supposed to damage the environment if you can help it, and the SAR Convention still applies, but it's going to be contextual. How does the SAR Convention apply between the conflict parties and uninvolved and neutrals? It gets, it tests the legal, I think it tests the legal parameters here. And communication, I've mentioned this already, communication of SAR response to prevent attacks on SAR vessels and aircraft. There will have to be means of alerting the belligerents to the activation of a SAR response if we're launching a lifeboat or lifeboats or to a search and rescue incident. Maybe it's a civilian SAR incident because the military stuff we'll leave to the military to deal with, or do we? How do we communicate that? What processes would there need to be in place to ensure, like a hotline, so to speak, between the parties to say, we're launching these assets and we're going from here to here, and here's the passage plan, and this is where we're going to, and this is the operating area, and we expect to take this long and be there for this long and return at this time. We'll be transmitting an AIS signal, but it could be jammed. All of those things, all the practical stuff that we need to work out, I think, and that may lead to some new practical guidance for the conflict situation. It's an interesting project, of which I don't really know what all the findings are going to be yet. There's going to be a lot of known unknowns and unknown unknowns and known knowns and blah, 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 all of that stuff. So I think that's the end of my slide. So thank you very much for listening to that. I think we are coming to questions at the end. So I'm going to introduce now Jaakko, who will talk about our Global Maritime SAR Systems Review project. So,
thank you, Rowley. I assume you can hear me as well. All right. So my name is Jaakko Heikkilä. I'm the International Program Manager at the IMRF, and I'm standing in for Steve, my colleague who couldn't join us today, who is leading on this project. My apologies for deviating a little bit from the topic of today, but there's been quite a lot of stuff to intake, and I sort of we'll give you now like 5 minutes time to collect your thoughts and put out some excellent questions in the Q&A. I'll talk briefly about another project that we are doing, which is a little bit related to the topic of the day as well, because it has a holistic view of the global system. So we are doing a review of the global maritime search and rescue systems. Basically, well, everything that it sort of deals with. Some of the challenges where this started from is that we know that there's a lot of regional disparities in the search and rescue capabilities, geographically and otherwise. In some areas, the cooperation internationally is working very well, whereas in other areas, we know that there are challenges in the cross-border responses. Again, some of the policies and legal frameworks are outdated, a little bit like we've been talking today. In addition, there's a lot of external forces, external factors that are challenging the search and rescue community, including, for instance, climate change, the geopolitical instability of today, and the associated phenomena, just like irregular migration, for instance. The economic volatility is impacting the global environment, but also the funding of the search and rescue resources. And we don't have too much data on which to sort of advocate our views in the political forum. So we thought that it's a good time to do a global maritime search and rescue systems review now, because first of all, as far as we know, such has never been conducted. The world is increasingly unpredictable, so we need that resilience, we need that preparedness in the search and rescue organizations. There's a lot of not only uncertainty, but also change in the world at the moment, including, for instance, technological change. And we as search and rescue community should stay ahead of that change. We should be aware of what kind of changes there will be and how we could adapt to those changes. And noting that many of these changes are not only challenges, they can be also opportunities. Clearly, technological change, for instance, is one factor which offers a lot of opportunities for the maritime SAR. And if we want to advocate our view within our own nations, internationally, and so on, we must have some evidence, we must have some data to support our course. And of course, we have a lot of information in certain parts of the globe. We need to make sure that we learn from others and we share all that we know. So that's why we're conducting the Global Maritime Search and Rescue Systems Review. It started already a couple of months ago, and it will be finished early 27. So it's a 20-month project, which is funded by the Lloyd's Register Foundation. And there are some of the objects of the review. So we're going to identify the critical gaps in search and rescue coverage and capacities. We're going to respond to emergency risks. We're going to promote equity and resilience and support long-term planning with recommendations for the next 10 to 20 years. And in doing all that, we're going to foster global collaboration. The project will be done in 3 phases. The first phase is basically the situation analysis and context review. So that means collecting all the possible data that there is, including academic papers, case studies, Cray literature, and so on, and putting it all together in a sort of understandable and readable format. Once that has been done, then it's time to do some stakeholder engagement and validation of that data. In other words, to find out whether those findings hold globally or whether they are regional findings, and what are the views of the search and rescue experts and stakeholders on that piece of information that has been collected. And this will be done through expert panels and workshops, and we're gonna employ some consensus building strategies as well. And once that has been done, then it's time to write out the reports and make up the recommendations of the project. What's been done already is that we have established an expert advisory panel representing several geographical locations, but also several different kinds of organizations. And we have also onboarded a research partner, C-Focus, who is going to do much of the data gathering. C-Focus is a consultancy and a content producer which specializes in the maritime, logistic, and shipbuilding sectors. And they have, for instance, supported a recent report by IMRF on the future of maritime safety. And then it's up to doing that context analysis, ensuring the sector input, ensuring wide geographical input, and then doing the communication. So we're going to be communicating on this project to our membership regularly. And of course, we're going to ensure synergies with the other projects that we are doing. But that was a quick run through. If you are interested in this global capacity review project, please feel free to contact my colleague Steve Wills, who is the project manager for this project. But now it's a time for the Q&A. I can see that there are a couple of good questions in the Q&A. So if I ask the speakers to turn on their video, and let's start with the question from Johan from the Swedish Maritime Administration. Johan is saying that it would be very helpful to have a simpler guideline or checklist for search and rescue agencies on how to look at the search and rescue units or RCC to take the right measures in uncertain times. And Johan is asking, is there such a guideline, or is there a plan to maybe do such a guideline? Rolly or Abby, which one of you would like to take that one?
I think that's the plan. That's our initial plan, Jaakko and Johan, is to create some basic check. We know that search and rescue people are practical people. They want checklists, work really well, short, simple, to the point. So yes, that is the intention. But what those look like is interesting. Given what I've discovered already, it's complicated. And it can be complicated, and it can be very contextual on the environment and the sea areas that the conflict is taking place in. It kind of changes all the rules around a bit. So yes, that's what we're going to do initially, and then whatever help we can provide to the San Remo and the Geneva Convention discussions about anything that needs modifying or adjusting. But the first priority is to develop something for our membership and for the SAR community more widely.
Thanks, Rolly. And there's a question from Thomas from Germany, who is saying that they have in the Maritime SAR service in Germany is working closely with the Navy helicopters for transporting personnel, equipment, or injured persons. And in the event of a war, could this cooperation lead to the rescue cruisers losing their status as civilians or non-combatants, especially if they are sort of seen together in joint operations? Abby, how do you see that?
Thank you. It's an interesting question. So in terms of whether it be if we're talking about sort of the helicopter itself, the Navy helicopters themselves, if they are not, so we have to kind of take a kind of the helicopters differently to the actual SAR rescue service, because the different objects might be used for different purposes. But when it comes to Navy helicopters, if they are exclusively used for the transport of medical goods and equipment, or for the purposes of exclusively transporting the wounded, sick, and shipwrecked, well, they will have the protection at the period in which they are involved in that activity. But if they are conducting activities that are also contributing to their military operations, such as they're transporting both rescue equipment for conducting search and rescue, but also equipment for military operations, then that does render the Navy helicopters at risk of losing their protection and then being attacked. Now, if we're thinking of the rescue service more generally, and the various capabilities that they have, if they are employing coastal rescue craft, and they are officially recognized as such, then they should receive the protections that are afforded to coastal rescue craft that I discussed earlier in my presentation, and they should remain protected. It's all about the functions that the rescue service is providing, and provided that they are exclusively being used for the purpose of conducting rescue at sea of wounded, sick, and shipwrecked individuals, then they will not lose their protection. But of course, there is the practical challenge with identification, and with all of the challenges I mentioned, and also that Rolly mentioned related to identification in modern day naval conflict. Even though one might be legally protected, practically it becomes a real challenge when you're operating in the vicinity of vessels or aircraft that might actually be targetable, such as that Navy helicopter, if it is not just exclusively involved in transport of individuals. So it's a very tricky question that requires thinking through operationally how to achieve the protection in practice.
Thanks, Abby. There's actually a related question from Paul about small rescue craft which is deployed from a warship to carry out the warship's SOLAS obligations. So is that rescue boat then a neutral by its status or search and rescue status? How do you see this? Is this different from the previous question?
So it is, there are some other aspects raised in that question which might be important to flag. So when it comes to this determining the status of something as a warship, that is something that is determined by states, and it must come from, they must register all of their vessels as warships, and they must satisfy the conditions that there must be external marks distinguishing character and nationality. It must be under command of an officer, and it must be manned by a crew under regular armed forces discipline. Now, in peacetime, status of warship matters for navigational rights. In law of naval warfare, it matters for belligerent rights. That's different to sort of the question of whether one is enemy or of neutral character, because you can have a merchant vessel, you can have a craft that is acting with enemy character, but it doesn't have the status of a warship. And if it is acting with enemy character, it is possible that it could be captured, and in certain circumstances, it could be targeted. So if a rescue boat itself is launched from a warship of a belligerent party, then it is not considered neutral. It is an enemy craft, but that doesn't necessarily mean it's not protected, provided that craft is being exclusively used for the movement of wounded, sick, or shipwrecked individuals or protected persons at sea, and it's only acting in accordance with that exclusive use, whether it be on a temporary or permanent nature, then it will be protected. Again, it comes back to the challenge I mentioned before about the practical issues with that, and that doesn't mean if it's just being launched in order to rescue, in order to pick up a member of the armed forces that is not actually, considered shipwrecked, then it may not satisfy, it may not receive the protection. They have to be, providing rescue services impartially for the purpose of rescuing the shipwrecked. Now, you mentioned the SOLAS obligation. You raise SOLAS in the question about whether it's what's required to meet the SOLAS obligations here. And I think one point is important to note is that this brings up the challenge that Rowley mentioned, is the interaction between SOLAS and the rescue at sea obligations under the law of naval warfare. Particularly when you have there may be some states involved in a conflict who might not actually permit either neutral vessels or enemy or vessels from a belligerent state to conduct their obligations in accordance with SOLAS for operational reasons. And in some circumstances, the law might actually permit that. And so and this goes back to sort of, the protection for small rescue craft. It's important to remember it's not absolute, and there isn't that additional warning requirement. And so communication between warring parties is very important, and also sort of understanding that in some cases it may not be feasible to implement the full extent of SOLAS, and rather something in those particular circumstances. But it's a very good question because it brings up lots of different challenges.
Thanks, Abby. Then let's go to the question by Captain Ruben from Malta. More about the process of updating the San Remo manual, pointing out that the United Nations Convention on the Law of the Sea and the San Remo manual have not been amended for a long time, or since the inception, and he's wondering if both documents should be revised at the same time in parallel to avoid possible conflicting terms developing. Has there been any discussion on that?
It's a really good question. What I will say is the UNCLOS, the Law of the Sea Convention, is considered to be the constitution of the oceans. It's arguably one of the most successful and influential treaties that have been adopted by states. And I don't sense that there would be any appetite from states to reopen UNCLOS for renegotiation, is my sense. But what is important about the update for the San Remo manual is that 30 years ago, when it was adopted, the UNCLOS was relatively new. Like it had been finalized some years before that, but it had only just come into force around the time the San Remo manual was adopted. So even though Law of the Sea considerations were incorporated into different aspects of the San Remo manual, such as its zonal approach, so you will see rules on passage through archipelagic waters. You will see the concept of due regard for neutral states' rights imported into the San Remo manual. We've had a lot of practice that has evolved since. We've had a lot of jurisprudence from the Tribunal on the Law of the Sea. We've had state practice. We've had evolving sort of interpretations. And so those evolutions in the Law of the Sea Convention and its application and implementation will be extremely relevant for the San Remo manual update. And some of those questions will be particularly challenging. Particularly because it raises the issue of interaction of legal regimes and how these rules apply, but they're fundamental questions that need to be answered, along with questions related to various IMO conventions.
Thank you, Abby. Then a couple of questions for Rowley from Andrew and Dominic about the identification. How do you see that? Andrew is asking about the enemy competent identifying the exempted vessels, and Dominic is pointing out the evaluating the possibility or viability of preserving distinction between civil and military characters of maritime vessels or infrastructure when the concept of whole of society defense is adopted in the country.
Well, the identification problem, I mean, Abby may have some points here as well. The identification issue is going to be a challenge in the visual identification, I guess, is easy. You paint the vessels as per the requirements of the Geneva Convention advice, and the San Remo manual says this too. That's relatively straightforward, but we know the world is an electronic world now, that maritime operates with an electronic picture, significant and widespread, global. In fact, you can track ships globally if they have the right equipment on board, AIS, for example, satellite AIS. So identifying vessels as SAR vessels is okay day to day. We can tell usually that a AIS signals the vessel is identified as a SAR vessel or a SAR aircraft, those that carry it. But in a war environment with a electronically jammed environment or electronically spoofed environment, it's going to be extremely difficult. I presume AIS wouldn't work very well. Radio probably wouldn't work. Radar would be jammed as well, so that the SAR vessel's own radars may be affected by electronic jamming. So, as I said, we may be back to a 19th century scenario, and I haven't thought that through. Could you do it? Could it be done? I don't know. So the problem is considerable if there's a full-blown modern conflict underway. If it's a low-level conflict, and Abby sort of mentioned there is some discussions around, I've forgotten the name of it now, Abby, was it, I can't remember the name for non conventional warfare and conflict situations may be different, where the warring parties do not have sophisticated electronic jamming capabilities, but they can still fire missiles at boats that they think belong to the enemy, and there'll be random attacks. So it's all very complicated, unfortunately. And how we get around the identification, other than visual identification, is going to be an interesting discussion, I think. I'm not sure about the second one from Dominique. Abby, maybe you can answer that one.
No worries. It's a good question, especially since we have a number of states thinking about whole of society defense in the context of a large-scale conflict, quite more in recent years. I think one point I would note is that when it comes to the conduct of naval warfare at sea, particularly in large-scale conflicts, civilian actors it's been quite common that civilian actors have always been involved in that effort. And I mentioned earlier in my presentation the use of auxiliary vessels. So the auxiliary vessel itself, the reason why it doesn't get belligerent rights, but it's still targetable, is because the civilians on board that vessel are civilians. They're not part of the armed forces, but they are inherently performing logistical and support activities that are enabling the conduct of the operations by the warring parties. We know that it's clear that there are not sufficient warships for belligerents to use, and logistics at sea, and particularly when conflicts are at scale, are a huge aspect, which is why the law on land warfare has to typically be considered quite different to the law at sea, particularly when it comes to distinction and proportionality and precautions, because you have civilians who are, there are some states that take the view that civilians on a vessel that is contributing to the hostilities assume the status of the vessel, and that once that vessel qualifies as a military objective, then it can be attacked. And in certain cases, if you're conducting capture of an auxiliary vessel, or you're conducting capture of an enemy merchant vessel, then there will be civilians on those vessels that may be detained. And if they are, then they will need to receive prisoners of war protections in the same way that combatants would. And that's how the law has sort of foreseen that there will be civilians participating in conflicts at sea. And I think one of the questions that is being explored as part of this, the San Remo manual update, and as part of our work on the global initiative naval warfare workstream, is, do we need to consider the influence of the law and its development in other domains, such as on land, in order to ensure that adequate protections are provided for civilians at sea. So if you have a merchant vessel at sea, civilian merchant vessel, that is, has some level of contraband, or has contraband on that vessel, but it's also transporting other important goods for civilians that have nothing to do with the conflict, then at what point does it become targetable? And even if it does become targetable, then how do we factor in all of the civilians on those vessels as well as the civilian objects for the purposes of proportionality assessments or applying precautions in attack? And so there are really, really important questions that need to be answered about how to protect civilians at sea under using, when it comes to the conduct of hostilities. And so it's a very a good question, because there is inevitably no doubt that in a large-scale conflict, merchant vessels and will be used as part of the hostilities. We know that history shows us this, but we also need to take account for the fact that the shipping industry has significantly evolved, and there will be many merchant vessels that will have nothing to do with the conflict that need to be protected.
Thank you, Abby. It's obviously a very, very complex issue. So let's take a perhaps easier question for Caroline related to the Search and Rescue Systems Review. Lisa from the British Ports Association Security and Resilience Group is asking that are we engaging with ports and logistics to ensure the alignment of the reception facilities and supply line resilience in the project?
Yeah, thank you. Good question. So with the Global SAR Systems Review, we've taken a really holistic approach. So we're keen to engage with all stakeholders in the global SAR system. And we spent London International Shipping Week really building up our connections and talking to key stakeholders within that about the Global SAR Review and how they could be involved. I sent you my email directly, and I know that also Margaret's very kindly, as IMRF host, put it in on the main chat. But really, if anyone does want to engage with that and be part of the survey, we would really welcome talking to you. So Lisa, it'd be great if you could email me directly, and then I can connect you to Steve and send you further details. So we'd love to have the opinions of the group that you represent in it. Thank you.
Thanks, Caroline. Maybe one more continuation question for Abby related to that warship carrying a rescue vessel. Paul is pointing out that maybe it's as relevant for a vessel that thinks it is or could be seen as acting to assist a casualty and needs to clearly state its intended status in some way, as much as whatever its default status is.
Just to say, I think it's a comment. If I've understood the comment correctly, I fully agree. It comes down to the rules themselves are. The rules are only useful in the way if they are practically implemented, and so the treaties themselves don't give us all of the answers, and we have to really understand how to best operationalize these considerations in order to ensure the best protection. And so this is why the IMRF will be performing a really important role as part of the San Remo manual update as an observer, because we really do need that practical experience and advice and guidance based on all of their members' experience in conducting rescue operations, so that we can make sure that the treaty rules themselves are implemented as much in good faith and are reasonable and practicable to ensure that that the intention of the rules is achieved.
Thank you, Abby. And there are no more questions on the queue. So I'll just note that this webinar will be published on the IMRF website. So if there was a little too much to take in, you can rewatch it there and make some notes and come up with further questions if you have. But at this stage, I just really want to thank all the presenters, Abby, Rowley, Caroline. Thank you very much. And thanks for everyone for joining us today. And if you have any further questions on the topic or the update of this UNRIMA manual, then feel free to email Rowley and he can address your questions later on. Thanks, everyone, and have a really great week.